Okay, so I think now record is underway, so the webinar has officially started. So let's get going with the first of our speakers today. I'm absolutely delighted to introduce my colleague and friend Magda Habdis, who's at the University of Silesia Katowice in Poland. Did I pronounce that correctly, Magda? So Magda's going to speak to us about the law in Poland. I'll just hand over to you from here, Magda.
Thank you very much. Thank you, Frankie, for having me. I'm delighted to be here, and I would like to give you some information about the regulation of apartment ownership, or as we call it, the ownership of units in Poland. Let me see if I can share my screen with you, which I hope I can. Let's see. Okay, so can you guys see this? Yeah, all right. Okay, so in Poland, we deal with apartment ownership as a special type of an immovable. So we distinguish between land and then units, and land can be an object of ownership and so can units. However, if a unit is to be an object of ownership, a special procedure has to be followed whereby that unit is isolated from the immovable as such, and it becomes a separate immovable. I don't think we need to get into the technicalities because that area of law works quite well, and it's very well done and performed and understood, and how to isolate a unit and make it a separate immovable, and thereby go into the regime of apartment or unit ownership. Condominium schemes or unit ownership in Poland gained importance after our shift to a democracy in 1990. And in 1994, we had a new act that was developed and that came into force, and it is called the Law on Unit Ownership. So if you count, a couple years ago, we just celebrated, 25 years anniversary of that act being in force. Now, when it came into force in 1994, it wasn't a very new concept because we've had ownership of units before. It's just that during the communist era, most of multi-apartment buildings were built and managed by cooperatives. And within those buildings, if you were the owner of a flat, which is to not saying it not in a very technical correct way, but you could own a flat within a cooperative building. What you had is a special cooperative propriety right to a unit. And the cooperative would be responsible for managing the whole building and indeed the whole housing estate. So the starting point in 1990 was that many buildings were owned by cooperatives, and that is still the case. And then the other very popular manner of holding a residential unit would simply to be a tenant of the municipality. What happened in 1994 is that when it comes to municipalities, a lot of units were being sold by municipalities to tenants. And in this way, in older buildings, because municipalities own older housing stock. So these are buildings that were built at the end of the 19th century, at the beginning of the 20th century. So these are older buildings, they're historical buildings. They do have a lot of repair and maintenance problems. And so the municipalities were very happy to sell off the units because in this way, they would be rid of the responsibility to maintain and repair the building. And now it would be the owners of units who were previously tenants that would have to cough up the necessary money and take care of the repairs. Nevertheless, unit ownership was embraced by the population. The Poles like to be owners of their units. We like to be owners of real estate. We have a long tradition in that. During the communist era, I think we're the only country that never completely abolished private and individual ownership, not when it comes to residential units, not when it comes to farmland. So, this is an important aspect of our legal system and of our legal mentality, if you will. So in the 1990s, this new act comes into force, and we are now able to erect new blocks of flats, new multi-unit buildings, with the purpose of isolating units, selling them off, and establishing a condominium scheme whereby the whole building is managed by the owners of units. And if you look at the pictures, then in the first picture, the top part, you will see a newer development. This would be built by a developer, probably after the year 2000, and this is more or less what these developments look like. The middle picture shows you a block of flats which would have been built during the communist era. As you can see, it's been refurbished. There has been some thermal insulation that's been done. That's also very common in Poland. These buildings are usually well maintained. And then in the bottom picture, you see a more historical building, and this would be typically owned by a municipality, or it could be completely privately owned. If it is owned by a municipality, then it is either rented out, or the municipality, if it does not want to have the obligation to take care of the building, sells off the units to people. So this is more or less the starting point, and this is where we are. Let me just say that a huge development of ownership of units and developing land with these new multi-unit buildings only became possible at the very end of the 90s and the beginning of the year 2000, because this is when the economic situation was strong enough for developers to actually have access to bank credit. In the early 90s, the interest rates were double digits, you know, like 16%, 18%, 19%. So economically, it was just not viable. It was only after they came down below 10% that it was possible for entrepreneurs to develop land, to build these buildings, and then sell off flats. So a real expansion and explosion of these privately built new unit buildings by developers, that began happening after the year 2000. Now, let me just give you insight how this ownership of a unit is organized from a legal perspective. First of all, the unit is usually a residential unit. However, please bear in mind that a unit can also be a retail unit or an office unit or a unit used for other services. And this often happens in new developments where on the ground floor, you would have either small shops or small offices or small services, for example, a hairdresser, you know, and so on and so forth. So not only residential, but also other uses are possible when you want to buy a unit. Now, the unit comprises, you know, apart from being a unit, so having rooms and a kitchen and a bathroom and hallways, the unit also has two important component parts. Legally, we treat them as component parts. The first component part, which you may or may not have depending on what your building looks like, would be a garage cubicle or a utility room or a basement cubicle that is assigned to your unit and that is legally attached to your unit. It means that it is a component part. So if you're selling a unit and that unit has as its component part, let's say a utility room, which is outside your unit, it may be in the hallway, it may be in the basement, it may be in the attic, that is a part of your unit. You sell the unit, you sell it together with that. These used to be very popular in older buildings. Most of them have basement cubicles that people used to store their bicycles or other things that they may want to put there and they don't need on an everyday basis. However, in newer buildings, very rarely do you have basement cubicles, because what happens is that the underground is used for underground parking spaces. So, you know, this is no longer the norm in newer buildings. Now, the other component part of a building, of a unit, is a share that you have in common property. And common property comprises two notions. So one, you have a share in the right of co-ownership of land on which the building stands. So you are an owner of a unit and a co-owner of land. And then you also have a share in the common parts of the building. And these are defined as all the parts that are not exclusively used by the owner of a unit. So basically everything that is outside the unit would qualify as common parts, and this includes the building, this includes the roof, the hallways, the staircases, the elevators, the outer walls of the building. This would all be this all comes in, qualifies as common parts of the building. Now, to calculate the share, what you do is, there are other ways, but the most popular one is you calculate the usable area of a unit and you divide that by the usable area of all units in a building, and this is the share that you have. Now, the share is an important concept because it determines four important things. First of all, it determines the strength of your vote, because voting is by shares, so the more shares you have, the stronger your vote is. Second of all, it also establishes the liability, because unit owners are liable for the obligations and the debts that they have incurred, and the liability of each individual owner is up to the value of their share. And then third, the share will also determine the cost that you bear in maintenance and how much proceeds you get if common parts do generate profits. For example, if there is a building and it has an outer wall and an entrepreneur wants to hang a big advertisement on that happens quite often, then of course they will rent this space, they will pay for it, usually some serious money, and this will be the profits of the residential community, and then they can use that money towards maintenance. So that would be the legal makeup of the concept of the ownership of unit. Another important technical manner is that a unit has a separate unit register. So we have a land registry, and land registry, as the name says, is basically devoted for keeping registers of land parcels. However, the same land registry has a section which is devoted to keeping registers for units. So each unit has its own land register, if you will, and the register of that unit indicates the number of the register kept for the land. And then if you look into so for example, if you're looking at a map and you see a parcel of land and you want to look into the register and see, what is the legal status of that land, if you look in the land register, you will find information of whether there is a building there and whether that building has units that have been isolated. And if so, that register will provide you with a link, will give you the number of the unit register. And there you can check the unit and see who owns the unit and, whether the unit is encumbered by a mortgage, and so on. So there is a link, there is between those two registers, which of course is a good thing, and in practice, this I would say this has been working quite well. So the unit itself is an object of ownership. It may be sold always together with the component parts. So when you're selling the units, you're selling the cubicles that you may have, and you're also selling the share that you have. And the unit, because it is an immovable, and because it is a subject and object of ownership, it may be encumbered by a mortgage. So being an owner of a unit is a very economically important thing. It's a very economically valuable thing. Now, a very important concept within apartment ownership is what we call the residential community. This is what the Polish legislator calls it. He calls it the residential community. And it basically means that all owners of units automatically, once a first unit is isolated and sold to a person other than the original owner of the land and the building in totality, once a unit is isolated, once it is sold to someone else, a residential community is established. And this happens by pure operation of law. Now, it is called the residential community, but of course, it is not really a residential community because the community comprises all unit owners. So if you have units that are commercial units or office units, especially on the ground floors, these people will also be a part of the community. So I think a better name for that would be the community of unit owners as opposed to the residential community. But for now, since 1994, this is what it has been called, and this is what we have gotten used to. Now, the one problem that we are having with the residential community is that it does not have the status of a legal person. So it is not like a company. It is not like a legal person that is completely separate from the members that it comprises. What it is a defective legal person, which means that it does not have legal personality, but it may still acquire rights in its own name and create obligations in its own name. It can sue and be sued. So it can be the plaintiff and the defendant in litigation. So far so good, but I will tell you that the fact that this is not a legal person does cause problems. I think the idea that the legislator had is he wanted liability to be shared between the community as such and the owners. And if you have a legal person, then what happens is that basically the liability is with the legal person, and then the members of that legal person are not liable with their own personal estates, with their own personal wealth. So in this way, because this is a defective legal person, the first address that you knock on would be the community of owners as such. And then if the community, which is a defective legal person, doesn't have enough money, then you can pursue the individual owners, each one up to the share value, to the value of the share that they have, would be liable for the part of the debt that the creditor is trying to recapture. The residential community really only has the capacity to manage common parts. It has no other function to perform. It is not allowed to do anything other. The only competencies it has is to manage the common parts. So it is not entitled to invest or conduct economic activity, even though, for example, the residential community would think, well, how about we open a business and then the proceeds of the business will allow us to cover maintenance costs and repair costs. They cannot do this as a residential community. If the individual owners want to set up a company of their own, and then the mission of that company would be to somehow provide income to the residential community, they can do that. But the residential community is only there to manage the common parts. We have two types of residential communities, the small residential community and the large residential community. The small residential community is no more than 3 units. So 1, 2, and 3, if there are 3 units within a building, so as you can imagine, it will be a very small building with only 3 units, then that is what we call a small residential community. Now, this provision has changed over the years because when the Act first came in, a small community was no more than 10 units. Anything more than 10 would be a large community. And then afterwards, that was changed to 7. So a small community was 7, no more than 7 units. Now it is no more than 3. Why? Why is that? Why have we scaled down the small residential community? This is because in a small residential community, the default management structure is that you use provisions contained in our civil code that relate to co-ownership and fractional shares. And what these provisions tell you is that when you are making any type of a decision which regards what we call ordinary management, there is no definition what ordinary management is. Jurisprudence tells us that ordinary management would be cost and expenses and decisions that are connected with everyday usage, everyday upkeep, everyday repairs. Anything that is more serious, for example, taking out a mortgage, conducting major repairs, major retrofitting, that would all be extraordinary management. So in a small community, I'm sorry, I got this mixed up on this slide. Ordinary management requires a majority according to shares. The majority of shareholders have to agree. And No, I did get that. No, I didn't get that right. Sorry, it's mixed up on the slide. So an extraordinary management, you would need unanimity. So in practice, the legislator envisaged that if you have 10 or less units, that was the starting point, people would just be able to agree. So even if they had to make a decision that regarded extraordinary management issues, like taking out a mortgage, major retrofitting, major repairs, I don't know, changing the manner some of the common parts are used, and so on, then the legislator assumed that 10 people would be able to be unanimous and agree on a solution. Now, reality verified that, and the legislator said, okay, so 10 is too much, people can't come to an agreement, let's do 7. And then after a while, it turned out that if you have 7 Polish unit owners, they will not be able to agree among one another. And so now it's been scaled back to 3. So if you only have 3 units, then the default management regime is for extraordinary management, you need to be unanimous. For ordinary management, you just need to vote according to the majority of shares. Now, in large residential communities, the default management structure is that ordinary management is performed by the management board, and that could be 1 or more persons chosen by community of owners. They can also hire a professional manager who will take the place of the management board, and that person or that board basically performs all the ordinary management activities individually. They are the ones who make the decisions. They don't need to go back and ask the unit owners what they want. Of course, at least once a year, they have to organize a meeting and they have to show what they've done. And if they aren't doing a good job, then they will be let go, or they will be substituted by other people. Now, for extraordinary management decisions, you do have to have a resolution. It is a majority resolution according to the value of the shares. There is also another manner of taking this, of doing this resolution. That is, if the majority of shares is owned by one owner, then holders of at least 1/5 of the total share value may demand that voting will be done according to one owner, one vote principle. And this allows to avoid a situation in which one owner who has more than one unit and happens to have the most share value is basically will be able to either veto any resolution or make sure that any resolution that he or she thinks is proper pass. So in order to avoid this, you can do a one owner, one vote principle if people agree. Now, I talk about default management, and the default management structure is described in the Act on the Ownership of Units. And even though the residential community may establish their own management principles, they can sign a contract which establishes new principles. That these principles may even be entered into the land register and the register of the units to show what the management structure is. In reality, that is not done. In reality, everybody just relies on the default statutory management regime. And this is why it is so important to get it right, because this is what is used, I don't know, 99% of the time. The residential community may only pass resolutions that regard the management of common property, because, as I have said, this is the only thing they are there to do. They have no other competency. They only have competence when it comes to managing common property. And of course, management of common property also allows them to establish the so-called house rules. So rules that tell you how you should behave, what you can or cannot do. The legislator does not provide for any other bylaws or constitutions of the residential community to be enacted. In practice, they often are. They just take the form of a resolution and they try and establish some additional rules of how the residential community functions. Whether or not they are legally binding, that remains debatable. And how enforceable they are, that remains debatable. Of course, as long as everybody agrees that whatever bylaws were enacted, they will abide by them, then we have no problem. But if somebody wants to question those bylaws, which do not really have a legislative basis, then they would probably be successful in doing that. Just a quick comment on house rules. Now, if these are adopted as a separate document, then they will probably have quite standard rules saying no noise after 10 p.m. and before 7 p.m. No storing trash in the hallway. I don't know, no using lifts in an irresponsible manner, and so on and so forth. But we would not find it possible to introduce rules which limit, restrict ownership of a unit. So, for example, no rules that say unit owners in this apartment building cannot have children, or unit owners in this apartment building cannot have dogs, or unit owners in this apartment building cannot allow their children to play ball in the outside areas. Okay, that would not be possible. That could be opposed, and the court would rule against such restrictions. Of course, you can have restrictions saying that children are not allowed to play ball in the parking lot because that may damage the car. But of course, children are allowed to walk around and play ball in other areas, even if they are not designated, as long as they don't damage other people's property and common parts. Now, the residential community, and I think this is important, in Polish law, does not have the capacity and the ability to impose any penalties on unit owners who either violate house rules or who, for example, do not pay their dues to the residential community. Because one important thing about the residential community is that because it needs to be managed and because the building needs to be maintained as well as the land on which it stands, every unit owner is obliged by law to pay an amount of money, which is established by the community as such, according to what the management board has calculated, or according to what the manager has said, or according to, if it's a small community, what they themselves have calculated. So they all need to, each month, they all need to pay a set amount of money to contribute towards the cost of maintenance and the cost of upkeep. Now, if they don't do that, or if they don't follow the house rules, so for example, are very loud and make it difficult for others to function, we don't really have any intermediate measures that we can use. The residential community, basically, the only thing that it has is access to court. And even to the point that the residential community may approach the court for it to allow for a forced sale of a unit. However, that is the absolute last resort, and the court will only do it if the violation of house rules are flagrant, they're very onerous, they make it impossible for others to function, they're dangerous, and if the unit owner does not pay their dues, then it is also possible to sell a forced unit, but the provision says that the person must be in arrears for a prolonged period of time. It doesn't say for how long, it doesn't say 2 months, 3 months, a year, for a prolonged period of time. So again, it is up to the court to decide whether the time where the payments are not being made, whether that time is enough to qualify it as a prolonged time. So as you can see, we have a.
Sorry, Magda, just going to say you've got another few minutes, and then we probably have to cut you off.
All right,
that's okay. All right.
So coming to the end, so basically, so three or four more minutes. Would that be okay? Yeah. Okay.
Perfect.
So large communities do encounter management problems. The main problems that we encounter is that when the resolutions are taken, there are many inactive owners or absent owners, and resolutions are pending for months. We do not have a regulation that says, okay, there is a meeting. If you come, then you can vote. If you don't come, we're still going to take the resolution because we will calculate the majority based on the people who showed up. That is not the case in Polish law. In Polish law, the majority always includes the entire population of unit owners. So if nobody shows up to the meeting, that means that it doesn't mean that the resolution has not been taken. It means that the resolution is pending, and the manager can, go around the flats and say, would you like to vote? Can you give me your vote? So sometimes it turns out that a resolution is taken months after it has been introduced. So this is very inefficient. We have no dedicated provisions to costly repairs, for example, energy efficiency investments, major retrofitting, major repairs. So there is a danger of neglecting the interests of less wealthy unit owners. There are no dedicated conflict resolution mechanisms. So if somebody doesn't pay up, if somebody is in arrears, the only thing you can do is take him to court. Now, there is a simplified court procedure that is available to all outstanding civil debts, but it is still a court procedure. It is not in any way targeted at or formatted towards serving communities of owner. So that is a problem. We also have constant tensions because the residential community is not a legal person. There are constant tensions on who does what. So, for example, if the residential community wants to buy adjacent land to enlarge a parking lot, is that contract concluded by the residential community, or must that and the representative, who is the manager, or does that contract have to be concluded by the unit owners, who then are not a residential community, but unit owners in a residential community? So as you can see, this gets very technical, but it makes things difficult in practice, and you have different court decisions regarding different matters, and it's just not a clear-cut case, and it is quite annoying and irritating to lawyers who, depending on which court jurisdictions are in, will face a court saying, no, this is to be done by the residential community. No, you need all unit owners to sign. It also becomes difficult when you're trying to serve court documents. So, for example, if the residential community as such took out a loan and it's not repaying the loan, who do you serve with the court documents? Is it just the manager, or do all unit owners need to be served as well? And the solutions that the court gives you change and vary. So coming to conclusions, things that we got right mostly is the concept of unit as such. The registers for units and land, they operate, they work quite well. And the obligation to contribute to maintenance and repair of common parts, which is established, you need to pay every single month, that is good. The things that we got wrong is that the provisions on management, how decisions are made, are very simple and very general. There is no regulation of constitutions or bylaws. There are no special voting mechanisms for selected matters. There are no interim measures to motivate unit owners to pay their dues. There are no simplified measures of forcing them to pay. So this makes it difficult in situations where you have owners who are not fulfilling their obligations, because the only recourse that you have is you have recourse to court. And that's a good thing. But if that's the only thing you have, as you can imagine, going to court takes time. It can be expensive. And if it takes the court too long to reach a decision, then basically going to court kind of defeats the point, because, the time to do something may have passed, or you're already losing money and so on. So the default management rules are inefficient. And we did have a conference because we celebrated the 25 years anniversary of our act. And in that conference, all the lawyers and all the managers, people who are involved in practice, said we need to have more detailed default management rules, so that not all cases need to go to court, and so that unit owners can be held more accountable. Please remember, many times the unit owners are absent. Many times the unit owners will be renting out their flats. So there needs to be a decision-making process that is in place if you have some inactive owners. And I think that is it. Thank you for your attention. There is a book that you can look into, Property and Trust Law in Poland, where I explain, among other things, unit ownership in more detail. So if anybody wants to have a bit more detail and the actual numbers of the provisions that I am referring to, then you are welcome to have a look into that publication. Thank you, and I'm sorry if I went over time.
No, don't worry at all. Thank you very much, Magda. That has been fascinating. I think one of the things that I picked up on that probably will be of interest to everyone on the call who's following what happens in Scotland is the way that Polish law uses a mixture of some of the things that we are talking about introducing in Scotland, but then also that you criticise Polish law for not having some of the other things that we are also thinking of introducing in Scotland. You know, there's all these different measures, and the question of how they all work together, I think, is one of the more difficult things about this area. So it was reassuring to hear that the kind of mini land registers that you have for each of the units in Poland, we are also looking at introducing something along those lines, and that does seem to be a very effective mechanism for making sure people have the information that they need. But it's very interesting to hear about how that defective legal personality of the community, the residential association, doesn't or no. causes the problems that it causes, which of course is something else that we're trying to overcome. So it's fascinating stuff. I'm going to just open the floor to questions for a few minutes. If anybody wants to unmute and switch your camera on if you've got questions that you'd like to ask. Which I think you do have the power to do that. Yeah, no power to do that currently. Okay, I think what we'll do is maybe we'll move on to Sandra and have Sandra's paper, and in the meantime we'll figure out what it is we've done with the settings that is preventing people from being able to talk, and then we'll take questions for Magda and Sandra together after. Oh, no, okay, so I think if you're there just now, Sandra, are you there ready to speak to us? Excellent. Okay, so we'll maybe move on to Sandra, and then we can have some questions about Poland and Portugal together at the end of Sandra's paper, if that's okay for you as well. Magda, you weren't dashing off, were you? No. Okay, excellent. Okay, well then in that case, let me introduce Professor Dr. Sandra Pasinis. Is that the right way to describe it? Sandra's a professor at the Faculty of Law at the University of Coimbra in Portugal. I know that Sandra's interest in condominium law started way back when she was doing her master's at the very beginning of her legal and academic career, and then has continued throughout that time. But Sandra also has a special interest in consumer law and sits as an arbitrator in consumer arbitration courts in for certain areas in Portugal. That's right, isn't it, Sandra? I've not just invented that. So that gives another angle of interest in these difficult dispute resolution questions that arise in the condominium context. So I'll hand you over to Sandra. Sandra, I'll give you sort of 20 minutes, and then I'll probably come in and start harassing you about time. Okay, thank you.
Thank you very much. Good morning to everyone. It's really very nice to meet you again. And I think I will ask Madalena to switch off the camera so that I can see my... Thank you. So I will try to share my presentation. Sorry.
Yep, that's looking good to me, Sandra. I can see that.
Okay, thank you very much. So I would like to start by telling you that in Portugal, condominium is regulated in our civil codes. That is from 1967, and this legal regime had two amendments, one in 1944 and one very recently in 2021. To be very clear, it goes along with what is happening in other countries in Europe. So you have this first generation regulation from the 60s, last century, and then at the end of the century, a second generation, and now the third one generation that is answering to the new challenges of condominiums. I would like to stress that our regime is to be found in our civil code, because In Portugal, the dogmatic structure of apartment ownership has evolved on the basis of property concepts rather than collective ownership or concepts derived from associations. So it is generally accepted that the concept of apartment ownership consists of two components, namely individual ownership of a unit and joint ownership, collective ownership of the land and other structural parts of the building. This means in practice, and I think this is the most important for you, that each owner of a unit feels that is the owner really that is enjoying a real ownership right rather than a co-ownership. This is also the result of the very limited powers of the organs of the condominium, namely the General Assembly or the manager of the condominium. So in Portugal, you have this very strong feeling of being the owner, a full owner of your unit. So each owner, I would say owner, is the individual owner of his units. And as Madalena said, it can be for residential, professional, commercial, or other purposes, and is a joint owner in forced division of the common parts, that is land and other elements like the outside shell of the walls and other structural walls, the roof, entrance halls, stairways, corridors. Well, I think it's more or less common to all of our countries, but also to common installations for services such as electricity, gas, water, and heating. So this is the structure, and over the unit you have, as I told, or you think you have a full property right, a full ownership right, and a full and a co-ownership over the common parts. As I told before, the management of the building is assigned to the community of owners, acting through the general meeting of owners that meets once per year, and the General Assembly, as Madalena said, for Poland, has powers only over the common parts of the building. So it would be not accept that the General Assembly would forbid, for example, pets in the building, or as you said the last session with the Australian case. So this would not be possible. This would not be possible in Portugal. Then we have the executive organ, that is the manager. The manager plays a very important role. The third generation regulations that I've spoke about before, they increase the powers of the manager, because people normally get absent from the meetings. People don't care, although they don't live in the building, so they don't feel the problems of the condominium. So the manager has a very important role here in the management. Of course, that if he has a very important role, he also has very important or very strong liability, and it should be, of course, also very qualified for this job. I would say I would like to give you a hint about the allocation of shares and rights. Developers or there are the owners of a project are allowed discretion to decide the formula to allocate the shares. That is the participation quota of the various units. So we don't have a strict parameter for the allocation of shares and rights. It depends on the discretion of the developer. But normally they set the quotas in relation to the relative size of the unit, the selling price, the conditions, interior or exterior conditions of the unit, the location, the degree to which the common elements can be made use of. So normally this is not a problem in Portugal. The allocation of shares and rights is expressed in a percentage on a per thousand proportion. And the participation quota serves first as the numerical qualification of an apartment's owner's share in the common property and in the benefits and profits flowing, for example, from the leasing of a common part of the building. But it is very important also, this allocation of the share, to allocate the number of votes of each joint owner in the general meeting, which is very, very, very important. And it also serves as the numerical basis for determining the financial obligations in respect of maintenance and administration of the scheme, which include in Portugal the contribution to a reserve fund. So now I get to the point about these financial contributions to the building. So I made this scheme. I hope it might help about the charges that you can have in the condominium. So you can have these general charges with utilities, regular maintenance, and common services. For common services, I would say, for example, the manager. It's a service. It's that the condominium contracts. But you can also have a gardener or a cleaning lady. So this is all the normal, I would say, normal maintenance of the building. You also have a mandatory reserve funds. And finally, we have these extraordinary works and renovation. So this is the charge, the scheme of the charges that you can find in the condominium. In what respects utilities, regular maintenance, and common services, as a general principle, you apply the proportionality rule. So it's very clear what anyone has to pay. But for example, for common services, they can approve an equal share. This equal share has to be approved by laws and by half of the co-owners, representing half of the total value of the building. So to make it clear, or to make it simple, the first rule is the proportionality rule, but if the condominium, for example, feels that there is a service that is a common service, and that everyone enjoys the service equally, for example, a swimming pool or even the manager, so they can agree that they will pay on an equal proportion, on an equal basis. If there are parts, common parts of exclusive use, for example, this might happen in Portugal, and it's very common because we have parts of the building that are mandatorily common. For example, the roof. But you can use the roof. You can have some installments of the roof, or you can have, for example, a garden that is common part, but that only one of the owners benefits from it. So in that case, we have an allocation of costs. The user, the owner that is using these common parts, that is mainly using this common part, will pay the normal maintenance, and all the owners will pay the works that have to do with the structural defects of the thing. So sometimes this is quite controversial in Portugal. In fact, we have this reserve fund. It's mandatory. It is equal to 10% of the monthly contribution. So all the co-owners have to pay. Well, we have a total amount of monthly to pay, and this total amount includes 10% of a contribution to this reserve fund. The reserve fund is functionalized to maintenance works. It can only be used to do these reparations in the building. And it shall be, I'm sorry that I left something here in Portuguese, it shall be put in a bank account of the condominium. The condominium is mandatory also as to have a bank account that can only be managed by the manager, can only be accessed by the manager and two co-owners. So this reserve fund is very important because it can help people when they have to do major works on the building. However, it can be, for example, you can imagine that there is an emergency that you need to use the money, that people are not paying their monthly contributions. So the general meeting can decide to use this fund for some other purpose. But if they do it, it shall be refiled, I'm sorry for the Portuguese, in 12 months by means of an extraordinary payment. So this has to be always, we have to always have the money of the reserve fund in the bank account. When it comes to extraordinary works or renovation, this is a very important charge. And there's, I think we have more or less the same problem that in Poland that Magdalena told, that we have also old buildings that need to, at this time, they need to have to be repaired, to be renovated. We have Portugal has a strong problem. It might surprise you, but we have a strong problem in the efficiency of the energetic efficiency in buildings. I know that we have a very mild climate, but the truth is that our buildings are not prepared for cold, and this is a very strong problem in Portugal. So these extraordinary works, or these works for renovation, rehabilitation of the buildings, they might be imposed by public authorities. And in this case, this is the simplest case, because municipalities can just impose co-owners to do the works, and they don't contest this order. But they can also be decided by the co-owners. For example, in Portugal, there is a rule that nobody complies with, that the building should be painted every 8 years. So, but sometimes when the condominiums have more financial better financial conditions, they do it. So in this case, the majority of the owners that represent 2/3 of the value of the building, they can just decide to do these extraordinary works. When it comes to lifts or gas, you only need to have the majority of co-owners and half of the value of the building. So the resolution needs a weaker majority. So in this case, when the co-owners decide to do the buildings, only 2/3 of the co-owners, but all the co-owners are obliged to pay in a first instance. And then they can go to court to contest this decision, and the court can decide that the expense was excessive, and then the co-owner has the right to have his money back. But in a first instance, in a first moment, he has to pay and he has to respect what the others decide. Normally, the point is not what the works that must be done, but it's the person who is executing the works, or sometimes you have this kind of conflicts in condominium. It's like that. I have not talked about the tenants, because in Portugal, the tenant is not liable for financial charges of the condominium. So, as I told you at the beginning, we have a property ownership that is very based on the property concepts, on the ownership concepts. So the relation is always among to co-owners. The tenant is considered a third person. In fact, it can be an agreement between the tenant and the co-owner that at the end the tenant will pay to the co-owner the financial charges of the condominium related to maintenance. But this is an inter partes agreement. It's lex privata between the co-owner and the tenant, and it's not enforceable against the condominium. So now straight to the point of our webinar, I would like to talk a bit about the guarantees. So since the new regulation in Portugal, April 2022, transfer of property inter vivos requires evidence of non-debt declaration or on the contrary, if there are debts, a declaration of the debt and charges. So the manager has to declare if related to that unit, are there any debts to pay. Without this declaration, the owner cannot sell because he is not enabled to formalize the title of transfer. As an exception, the acquirer is entitled to overrule these requirements, but he or she becomes liable for debts and charges. So this solution was already the French solution, and now in Portugal we adopted it. So it's a very recent one since April 2022. In case of non-payment, and now we are on the core of our question, how to enforce payment for tenant maintenance. So the manager has to react. He has to react against the person, the co-owner that is in arrears, that is not paying the financial charges. And the law is so specific that he has to react within 30 days. The manager can do it, and he has two ways to follow. So you can do it in directly. You can go directly to an executive procedure, and you can do it because after the meeting you write a report of the meeting, and this report is an executive title. So you can go directly to the execution proceeding. However, normally people don't do it, managers don't do it, because the courts of execution proceedings are working very slowly, and also because you enter this judicial procedure and then you have to discuss all the problems of the resolution, if it is valid, if it is valid, you have to do it within this executive procedure. So in Portugal, we have a very simple way to react against these non-payments. It's the judge of peace. The judge of peace is like a kind of alternative dispute resolution, and he has competence over condominium matters. So what normally managers do is that they go to this judge of peace against the co-owner that is in default. In the judge of peace, they have a first moment of mediation. It's not mandatory, but normally people accept mediation. So in mediation, they can talk. The manager can talk with the co-owner that is in default, and with the help of the judge, they can understand that the deliberation, the resolution is valid or is not valid. So they have this first moment of mediation. If it does not result in an agreement, and so they will follow to the judgment, and the judge of peace will enact a decision. This is a judicial decision, so it is a first instance judicial decision. After the decision, normally people pay. But if they don't, now they start with the executive proceeding. But at this moment, as your title is a sentence, the manager is much more safer, and it can foresee that the executive procedure will be really simple. I would like to finish with this with a final remark. In what respects the enforcement for payment for tenant maintenance, I think that we have the legal means in Portugal, that we have foreseen the legal means that will provide the right solutions. In fact, we don't have this idea that it's not possible to enforce the payment of financial charges. No, we don't at all. So we all know that if the co-owner does not pay, that we will have problems. That's very in a very short time, they will have a decision against him from the judge of peace. It is the current way to how things work. However, we have the social order, and the problem with the social order is that sometimes people just don't have money to pay, and against that you cannot do anything. You have to accept. And in Portugal, we are now, I think in Europe, we are undergoing this crisis, and sometimes people just don't have money to pay. For example, they can pay the maintenance charges, but they cannot pay the extraordinary works or renovations, rehabilitations. So in that case, there is nothing we can do. But this is for the social order. In what respects the legal order, I think that we have the mechanisms that are sufficient and adequate for the enforcement of financial charges. So I would finish here. I don't know about the time, but of course I'm available for questions.
Brilliant. Thank you very much, Sandra. And also that was excellent timekeeping too. So we're all good there. That's really interesting. I imagine that some people in the audience might have some questions about the judge of peace. I suppose here we might call that a justice of the peace type procedure, that kind of light touch, speedy resolution to these payment disputes when they arise. But it's also interesting to hear that in Portugal, there are legal resolutions available when you have somebody who has the money to pay but isn't doing it, so that there's a solution to that problem. But there isn't really a solution to the problem when you have somebody that just doesn't have the money to pay at all. And that's definitely a challenge that we are also looking at in this country. Okay, so I think we have now been able to make it so that members of the audience, you should be able to unmute yourselves and put your cameras on if you want to ask some questions. So if people have any questions now for Magda or for Sandra, then please go for it now. Ilsa. Hello, we can see you.
Hello. I had potentially a very simple question. Sandra, you mentioned that there were some other regulations, such as people having to paint their properties. I think you said something like every 7 years, but people ignore it. Is there a wider issue around enforcement of issues around maintenance more generally that obviously sits parallel with this? And I just wondered if that came into any of the discussion.
Ilse, can you please repeat, because I think I have an internet problem.
No problem at all. You mentioned that there were rules that people didn't abide by, such as having to paint their properties, but they didn't. I was just wondering if there's
I'm saying the properties charges.
Okay, no, I think I've potentially misunderstood. No,
I'm
no
sorry,
problem.
maybe it was my fault. So what I think at the end of my presentation, what I was telling and Frankie was commenting on it is that we have the legal instruments to react against a default owner. But sometimes, and it's very common in Portugal, people just don't have the money to comply with. And when you don't have the financial conditions, when you are a vulnerable, financially vulnerable person, at that point you don't have, there is nothing you can do. I could imagine, because Frankie said we have to deal with this problem. It's true. We have to maybe a guarantee from the state, or like someone. For example, during the pandemics, the National Agency for Habitation, they made like a kind of a borrow. They borrow money to the landlords that they would pay the rents. They would borrow the money to the tenants. They would pay to the landlords, and then they would return the money. So maybe a kind of a system like this, that you have a statal system that might help you. For example, about the reserve fund, it is mandatory, but sometimes you live in a building when 2 or 3 people do not pay, and you might be very surprised. Do you know who doesn't pay? For example, banks. When they get a house, in Adácio, in Salvendo, they don't even make the registration of the acquisition, so that the condominium does not know who is the owner. So, okay, we have this problem. Sometimes the developer does not pay also, but sometimes people do not have money to pay, and in that case, the manager who uses the reserve fund. This is very common, and there is nothing you can do against it. Of course, law cannot change the world as such. I'm sorry.
No,
I'm sorry,
thank you.
I talk too much. Sorry, Frankie.
No, that's really interesting. Thank you, Sandra. Is that okay, Ilsa?
Yeah, that's absolutely fine. Thank you.
Thank you. Jackie Timmins, do you want to jump in with a question there?
Yeah, thank you. Thanks, Frankie. So it was about the voting, Magda, in Poland. And to understand, I didn't really understand. So it's not voting 1 vote per flat, it's voting in accordance with the share of the ownership that you have in a block. But if the majority, the person sort of tries to force through to a majority, the people can ask for 1 vote per flat. What difference would that actually make to the result of the vote? Because I'm thinking about my situation where I work for a local authority and we have social housing that some owners have bought back apartments within. And so if we still own the majority, we can always sort of get a vote through. But it was just to understand that difference, if that's okay.
Yeah, it's not 1 vote per 1 flat, it's 1 vote per 1 owner. So if you have the same person owning 5 flats, that person still has 1 vote. He's counted as 1.
Right, okay, I get you.
So then you would overcome the problem that he has either the majority of votes or the majority of flats, so he will always get a resolution through depending on what he feels like. But if it's just 1 person, 1 vote, 1 owner, 1 vote, regardless of how many flats they have, then that evens the situation out. And you can achieve that either by all of the unit owners agreeing in a regular resolution using the regular majority of shares. If they can all agree and the majority agrees, yes, it's fair to do it, then you can do it that way. Usually they will not agree, and then you have to collect 1/5 of the share value of votes, and then the 1/5 can say, okay, from now on, or in this matter, we vote 1 owner, 1 vote, not 1 flat, 1 vote, 1 owner, 1 vote.
Okay, so in our situation, if we have a social housing block with 6 flats and we own 4, and there's 2 other owners, then there's only 3 votes that we need the majority on. And does everybody have to vote?
Well, the thing is that if you want, you have to have the majority of all votes available, not just the majority of the votes of people who showed up to the meeting. right?
Yeah. Okay, thanks.
And that, just to follow up on that, Magda, in that situation where you've got, say, one person that owns 50% of the flats or 50% of the property, if that resolution is passed, they only get one vote, but presumably they are still liable for 50% of the costs then. Okay, all right. I think this is quite a difficult question, how to balance out majority and minorities within apartment blocks, because my concern for what's been proposed in Scotland is whether we've got sufficient minority protection, particularly in a context where maybe the minority that's one person or two people, they don't have the money to be able to pay for the large scale renovations that are perhaps being proposed by the majority. So you're sort of, on the one hand, you want to protect the rights of these minority owners, particularly if they're in a more vulnerable situation for one reason or another. But equally, you don't want one person to be able to block works that everybody else wants, especially if it's work that really needs to be essentially carried out, say, for climate emergency reasons. So that's it's interesting.
I mean, you don't want to go from one extreme to the other. You don't want to go from the extreme that you're protecting the majority to the extreme that you're only protecting the minority.
Yeah.
But can I just give you an example? In practice, the problems that we have had were mostly that the majority wanted to push something across that the minority wasn't happy with. And that majority was quite often the municipality, who still retained ownership of most of the flats. And what happened was, for example, before election period, and they own historical buildings and old historical multi-unit buildings. So they decided, okay, let's renovate, let's do this wonderful, facade renovation and make everybody else pay, because they could outvote the minority, and at the same time put very serious financial obligations on them. And and sometimes this was done basically to further political interest, because then that municipality said, look, we're taking such good care of our buildings. That, of course, was opposed through a court procedure, because you do have access to courts and saying if the minority is not performing its obligation with appreciation of minority interests, you can go to court, or you can also say that this is contrary to prudent management principles, right? And the court will say, it's lovely that you want to do this, but this is too expensive. It's not prudent. It's not the time. It's not the place. You haven't accumulated enough money. So you can. And that was opposed to courts, usually with success. But the fact that you need to go to court and you have to go to that next level, that you don't have any mechanisms to resolve it on site, and you don't have any, safety instruments, that motivate the majority not to do this, is a bit of a worry, because you can't run everything through a court, when you need to manage this on an everyday basis.
Can I just add something?
Yeah, go for it.
I'm sorry. Of course, also in Portugal, we also have this excessive expense criteria that you can go to court. But I would like to add something on what Frankie said about the minorities. In Portugal, Portugal is not worried at all with the protection of the minorities, because the main public policy is on the rehabilitation of the buildings. This happens by the lack of dwellings available in the markets. So there are no new buildings. And also because of the tourism and of the cities that have to be enjoyable for this purpose. So we have a strong politics of rehabilitation, of coercive works, and it's not yet an issue, the protection of the majorities as such. It's not on the balance.
Okay, it brings us back to some of these interesting cultural questions again, I think, about what people will accept, but that's really interesting. Were you going to come back on that, Jackie?
It was just very quickly to say that Magda's point about forcing through works, I think that our Tenement Act at the moment limits the works that we can do. It's got to be reasonable, it's got to be repairs and maintenance, so you can't just improve or alter the building under the current legislation.
Yeah, absolutely. Okay, so I'll take a question from Susie Robertson, and then we better move on to our other two speakers after that. Susie, if you want to make yourself visible and hearable, that'd be great.
Hi there. I'm worried that this isn't a particularly short question, but if there is a way of answering it succinctly, that would be great. I'm really interested in how both Portugal and Poland have set up the shares for units.
Oh dear, I think we've lost you, Susie. You're freezing. Always just at the exact moment you're trying to speak.
And we don't know if she can hear us, right?
No, I don't know.
But I'll stay here so until the end, so we can postpone the question, Frankie.
Okay, all right. Well,
Yeah.
I think that's what we'll do. I think we'll move on to our next speaker, who's Sergio, and we can maybe even ask Susie to put her question in the chat when she can find her way back in, and then we can pick it up a bit later on in the session. That's a shame. Okay. All right, well then, in that case, let me introduce you to our third speaker of the day, who hopefully is still with us there. This is Professor Sergio Nazar Aznar. Sergio is a full professor of civil law at the University of Rovira i Virgili, apologies for that pronunciation, in Tarragona in Spain, and is also the director of the UNESCO Chair of Housing at the same institution. So Sergio's expertise is across housing law, and he has also researched and written extensively on tenancy law, on eviction, squatting, homelessness, as well as his interest and his expertise in apartment and condominium law. So again, he's bringing in some other aspects of expertise that I think are very useful for the discussion that we're having today. So I'll hand over to you now, Sergio. Again, I'll give you sort of 20 minutes or so and then start hassling you about time.
Thank you very much, Frankie. First of all, I wish to thank you. I think to thank Professor McCarthy and her team for inviting me, for inviting us. And also, I am so proud of being together here in this panel with these distinguished professors around Europe, our friend Magda Habdas and Sandra, Pasinis, and Vincent Sager. So thank you very much. I am really, really excited to be here with you today. I am trying now to share the screen. Let me check if it works. Hopefully you are seeing it now.
Yep, that's right. We can see everything here. Thank you.
Okay, that's very nice. Thank you very much, Frankie. So basically, I will devote the first 5-6 minutes to go across our general rule for condominiums in Spain, and then I will focus on the 6 remedies. There are 6 remedies that the condominium has against the delinquent co-owner that has debts that owes money to the condominium, basically. So first thing, here's the table of contents. Of course, first is the challenge, what we should sort out. Second is this framework of Spanish condominiums. Third is the legal framework for the delinquent co-owners, and then we will draft some conclusions out of all. Basically, the challenge is clear to me. I mean, we have to move on from the traditional Roman co-ownership that comes from year 300, 400 before Christ, and that is in essential inefficient, which means that when you have several co-owners, all of them, this joint co-ownership, they jointly own a thing, a good or a property, and then they cannot do anything by themselves. They have to agree upon everything in relation to the thing. Also, they have to agree on the use and the disposal and the charge and everything, and it's a mess. It doesn't work. So we have to move on from that traditional co-ownership to a more efficient one, where every co-owner has a sort of freedom in relation to one unit, and then has a sort of co-ownership or a common right for the common parts, like accesses, utilities, facade, roof, stairways, and so on. That's why we came up with this concept of condominiums. We have heard already some examples in Poland, in Portugal, and then we'll talk about Belgium. And here are some pictures about many uses of condominiums. Of course, we have the regular one. We have the supra condominium. We have here for each of those buildings, there is a condominium, and then above them, above all these 6 or 7 condominiums, there is a super condominium which coordinates all of them, and they have this. The super condominium has these common parts of a garden. You see a swimming pool there and everything. We have also the lying condominium, which is a condominium used for semi-detached and detached houses. that share also some facilities like you see at the tennis court there, the swimming pool and everything. These all are pictures from my city, from Tarragona. And then we have even this graveyard condominium. We organize our dead people also in niches, and they are organizing condominiums as well. But we are using condominium also for shopping malls. We are using condominium rules for stalls in markets. We are using condominium rules for parking slots in parking spaces, and so on and so forth. So condominium, I have to say, is popular in Spain. In fact, not by chance. Spain is the country in Europe with more people living in flats. 66% of people live in flats. I have lived in a flat all my life. Very few people live in semi-detached and detached houses, and most of these flats are organized in condominiums. Of course, there are other ways in organizing multi-unit buildings, like cooperative housing or associations of homeowners or time sharing and so on and so forth. But you see here some numbers. So there are only 11,000 dwellings organized as cooperative housings out of a stock of 26 million units, which means that these numbers are basically irrelevant. So condominium is paramount, is very well known, is very natural among people in Spain. And you see here, we are the highest country because this in 2020, this is an outdated graph of 2018. Latvia was before us, but now we are the first ones. Yeah. So, and why is that? Well, basically, it is because our law is very good. I mean, I have to say. Our law comes from 1960, and it has changed very few times. It has a clear definition of what a unit means. These are those parts of a building that are capable of being used independently because they have access to a common element of the building or to a public way. That's it. This is a unit. And then also it has clear rules for the legal nature. What condominiums are? Condominiums are an exception of superficies solo quedi. Professor Habdas has already addressed that. And they don't have a personality like in Poland, but they are personified, which means that the law makes a lot of exceptions. Unlike Poland, I have understood there are some messes, some problems there. I mean, it's quite strange. It's a fiction. It's a legal fiction. Yeah? And say, okay, we need somebody to contract the utilities or some facilities for the condominium. Okay, the condominium does that. Yeah, which means that it is a legal fiction. Although there is also a joint liability of all owners. But basically, the condominium arranges all the paperwork and things like that. Also for torts, also the condominium has a reserve fund, as our colleague Professor Pasinis has addressed in Portugal, and so on and so forth. Second clear thing is that an authority creates the condominium. We have notary publics. They create the condominiums, and they are promoted by the developer if it is a new building, or by the unanimity of some co-owners, let us say Roman co-owners. Imagine 3 heirs that have inherited a cottage in the countryside that can be divided in 3 or 4 units. And then it is very simple for them to transform that Roman co-ownership into a condominium, because then they can take 1 unit for one of them, for each of them, and then they can sell, mortgage, rent, or whatever, that single unit as they wish. And they don't need the consent of the other heirs. This is a very good advantage. It's very good. It's working quite well. And also there is a publicity in the land register. It is clear that that building is a condominium. It has its own record in the land registry. And also there is a record, as in Poland, I have understood, as well a record for each of the flats. And everything that happens to each of the flats is recorded in their own sheet of the land register. So there are 3 main features. There is full private ownership over the apartment or the unit. Second, there is a co-ownership over the common areas of the building. That these common areas can be, you see here in the little picture here, outside the building, inside the building, you know. And there is the share that represents the rights and obligations of each apartment over the whole building. The share is determined on the basis on square meters, the surface of each of the units, and also the use of the unit. Following your discussion before on how the decisions are voted, we require both the majority of votes of units, so each unit has a vote, and also the majority of shares, which means that, for example, a unit may represent an ideal share of 10% over the whole building, but there might be another bigger flat that represents, or a commercial space that represents 25%. So if we need to require a certain majority, we have to count both the majority of votes, 1 vote per unit, and also the majority of shares. And it works. It's working quite well. There are more details here, but because of the time, I want only to say that thanks to this very well done law on co-ownership since 1960, Spain has been capable of widespreading home ownership to regular families, even to middle class and middle class or even low class families. Spain is the Western European country with more people as homeowners. 47% of Spanish people are homeowners without a mortgage, and all of this is thanks to the condominium. Let's start with the core of this webinar, which is the legal framework for delinquent co-owners. First, some data. Depending on the surveys, there are between 24% and 61% of condominiums without delinquent neighbors, with delinquent co-owners. There are 2 studies. One is made by ourselves, by the UNESCO Housing Chair. Another was made by the College of Professional Managers of Condominiums. And we came up with different data. But the message is that there is a big share of condominiums that there is at least one delinquent co-owner living within. Second thing is that only 7% of delinquency cases are solved through arbitration or mediation. So 93% end up in a court, in a trial. And finally, delinquency is the second source of conflict among condominiums after noise. You know, when we live in condominiums, we have neighbors above, below, on the left, on the right, and noise is the first complaint everywhere in Spain. Second is delinquency. So 42% of surveyed co-owners said this is the second biggest source of concerns within condominiums. So let's start with these 6 remedies, 6 actions, 6 possibilities that condominiums have at hand to use against delinquent co-owners. First thing is the lack of voting rights of delinquent co-owners. So delinquent co-owners are deprived from voting rights in every condo assembly, although they are allowed to attend and to intervene during the discussions. Sometimes they are so ashamed that they don't attend. But if they attend, they go and they can discuss, but they cannot vote. Second thing is that in the minutes of each meeting of the condo assembly, there will be included a list of delinquent co-owners with their names and the number of the flat, who share on the condominium and their own vote are not counted for any purpose. So if a certain majority is needed to be reached, to agree upon a decision, they are shared, the flat that is burdened, the flat that owes money to the condominium, and the vote of the defaulter are not counted at all. So only the other ones count. Second remedy is that delinquent co-owners are named in each call for the next General Assembly. So there is in Spain, according to the law, there is one compulsory General Assembly per year where all the co-owners are invited to attend. But in that call, in paper usually or through the internet, all the names of delinquent co-owners are listed with an alert, with a notice saying that if she or he hasn't paid it owes money to the condominium, he or she will be deprived from voting during the assembly. Of course, they will be able to vote if they pay the arrears before the assembly starts. Third remedy is that delinquent co-owners are not allowed to challenge the agreements adopted in the General Assembly. Usually, those co-owners that opposed to a decision during an assembly or did not attend to it, or when a decision was illegally taken, can challenge that decision. in court. They can go to court and say, okay, I voted against, I don't agree with the decision, I think it's illegal, I think it goes against the bylaws or whatever, so I can challenge, and any co-owner can challenge the decision in front of a judge. But not if you are a delinquent co-owner. So basically you are expelled from the political life of the condominium. And you see here, this is an important change this year. This is to facilitate the use of EU Next Generation funds for rehabilitation in condominiums. There is a general agreement among professionals that, because you have seen the numbers before, that delinquency is not sorted out in condominiums. It's a quite normal phenomenon that happens usually. I mean, it's a common fact. Yeah. So the legislator said, okay, we have been granted a lot of money, millions of euros from the European Commission, and we want to invest them properly, and we don't want delinquent owners in condominiums to block or to mess around all these things. And what they have done is to introduce the possibility of to pass dissuasive measures in a given condominium. So the condominium assembly can do two things. First, they may agree upon with a simple majority of votes. When I say simple majority of votes, means the majority of votes of those attending to the assembly, or it's either or they may include in the bylaws, and for this unanimity is required, to introduce any kind of dissuasive measures against delinquency, provided they are not abusive or disproportionate. This is a very new thing. It's quite new. It's quite striking. Some judicial decisions accepted them, some others didn't. But now it's clear in the law that the assembly can do these two things: either agree or even introduce these dissuasive measures in the bylaws. There are two other limitations for these dissuasive measures. They cannot affect the habitability of the property, nor they can be retroactive. So they cannot have effects to the past, only to future events. There are some examples already. For example, the assembly can agree to introduce in the bylaws or simply take a decision to charge higher interest rates to prospective future. Remember, this measure cannot be referred to past events, so prospective debts, than the ordinary ones. Legal interest rate for 2022 in Spain is 3%, which means that basically the assembly of the condominium can agree that any defaulting debt in the future in the condominium will be charged 5%, 7% of default interest rates. Can be higher than that. Well, I mean, we have said that this measure cannot be abusive or disproportionate. So maybe more than 6, 7% or 8% even could be perceived as abusive by a judge. So this is possible, but with limits. And the second example is that they can impede the defaulter to use certain common spaces or services. For example, the swimming pool or a tennis court, but not the elevator, for example. The elevator would affect, so barring a delinquent owner from using the elevator will affect the habitability of the property. So this will not be allowed. And how? So I have asked myself, how are they going to enforce this? Well, the most practical way is requiring mechanical or digital tools to access. A key, a password. You can give keys to every other co-owner, but not to the delinquent ones, or a password to other owners and not the delinquent ones. You can do that. But if you cannot do that, or you haven't thought about this, and something like this happens, and you have a delinquent owner that, for example, insists in using the swimming pool when he is not allowed to because the decision has been taken, or this is specifically foreseen in the bylaws, then from my perspective, this is very new. This is only from June this year, so it's very new. But from my perspective, the condominium can go to court and ask the judge to force the delinquent co-owner to stop entering into the swimming pool, for example, according to the bylaws, or even if the co-owner insists in his behavior, This decision, this court decision, may contain the expropriation of the use of the unit of the delinquent owner up to 2 years. Sorry, 3 years. In Catalonia, 2 years. And finally, this is the final one. Sorry, no, this is the fifth one, but it's related to the last one. Personal liability of the delinquent owner and privileged credit of the condominium. The general rule is that the owner of the unit that defaults in paying, for example, the maintenance of the condominium, his share, of course, of the maintenance of the condominium, the extraordinary expenses, his part or her part of the reserve fund, or his or her share on any debt of the condominium before third parties, service utilities, and so on, is personally liable for that. And her debt generates interest since the very first moment. This is a very important statement in the law. This is very important. Second thing is that even if this can be solved through mediation or arbitration, we have seen this is very rare. So the condominium has an statute of limitation of 5 years to go to court since the debt was generated. If the delinquent owner cannot be properly notified, saying, no, I didn't know anything about that, I didn't attend any meeting, I don't know what's happening, and so on and so forth, then the secretary can simply announce the claim, placing a notice in the bulletin board of the condominium. So everybody can see when entering into the elevator, for example, or the hall, the name of the delinquent owners that are going to be sued and have a problem with their payments to the condominium. Third, of course, data protection is an issue here, but some courts have accepted that this is necessary. I mean, because people cannot simply say, no, I didn't know what's happening here, I didn't know I owe money to the condominium, I didn't attend any meeting, I don't know who these people are, and so on and so forth. That's it. They hang a piece of paper with the name, you owe this money, and you're going to be sued. That's it. Third thing is the condominium's credit rank is very high. So the credit, the action, the claim that the condominium has against the delinquent owner has a very high rank. It's not an ordinary loan, an ordinary credit, an ordinary loan. It even ranks before the mortgage that the delinquent homeowner might have taken when he bought the property, even if the debt came after. The debt against the condominium came after. Which means this is a tacit charge that might appear at any moment during the ownership of that person, of a given person, of an owner. So the banks have to know that, they know that, and they charge usually interest rates because they know there are always this kind of hidden charges that might appear, including this one. But this credit ranks after any money owed to the public administration, insurance companies, or wages. And finally, the condominium has a special process, a judicial process. Is called monitorio. It is rather fast. In 2021, this process used to last as an average 8.6 months. What you may think, okay, this is not fast. Okay, but you compare with ordinary cases, it's 17 months. Any ordinary case lasts 17 months. And if you compare to a mortgage enforcement case, it is 40 months. So it's rather fast for Spanish standards. And the decision is simple. I mean, there must be an agreement by the condominium assembly, and even the professional manager can start all the paperwork to start the procedure. And finally, this is the final remedy: the tacit legal charge over the delinquent unit in case it is sold. Of course, if you are a delinquent owner and you don't want to pay anything, and you are pursued, and you find that you are going to get into trouble, you might think that selling the property could be a good solution. Say, okay, sell the property, I forget about all this, and I go out, and that's it. Well, the law has thought about that. All these measures, except the one of the one that I mentioned before, this prevention of use of common spaces and so on. All this already existed in 1960. So some of the measures I have heard from Poland and Portugal that have been introduced 25 years ago, or in Poland even this year, they existed in our law from many years already, and they are working. Yeah? They have been polished a little bit, but they were there. This is a very paramount one, saying after the sale of a unit, which former owner still owes money to the condominium, the unit becomes legally and tacitly charged for the payment of the due amounts of the current year plus 3 years before. This is 4 years in Catalonia. So all the emoluments or the money owed this year and 3 years or 4 years in Catalonia before, they can be paid enforcing, foreclosing the property. This works like a mortgage. This is a sort of tacit legal charge. Yes, that even ranks, as I said before, an ordinary mortgage. The public deed, that includes the transfer of the property, must contain, this is the new measure I have heard in Portugal, this existed for many years in Spain, must contain a declaration signed by in the public deed with the public notary of the sale contract. The public notary will not draft the deed of the sales contract until he gets a certificate by the secretary of the condominium stating whether the condominium owes money or not and how much to the condominium. And once he has the certificate, then the notary public will show the certificate to the buyer and say, do you want this? Do you want to buy this? Even if it owes money to the condominium. If he says yes, then the property is charged. And then the property, and if the debtor, the real debtor of the condominium doesn't pay, the property will be foreclosed. So there might be three situations. The debt is assumed by the buyer, and this debt assumption is accepted by the condominium. You know that according to regular civil rules, if you change a debtor, if the debtor wants to be changed to find another debtor, this must be agreed by the creditor. This is regular nearly everywhere. Yeah, I mean, it's not the same to have a debtor A or debtor B. So debtor can simply switch or find another person as a debtor without the consent of the creditor. So if the debt is assumed by the buyer and this assumption of the debt is accepted by the condominium, okay, so the buyer is both personally liable for the debt and the unit is still charged for that debt as well. Okay, no problem at this point. Second is that the debt is assumed by the buyer, but this assumption of debt is not accepted by the condominium. In this case, the seller remains the personally liable for the debt, but he can recoup from the buyer because the buyer assumed the debt and probably a discount in the price of the property. But anyway, if by any chance the seller doesn't want to pay, the condominium can foreclose the property, can foreclose the unit, even if it is in the hands of the new buyer. And finally, what happens if the debt is not assumed by the buyer? Then the seller remains personally liable before the condominium. But if the condominium decides to foreclose the property, because, the seller doesn't care, he has gone to Hawaii and that's it and forgot about everything, then what happens is that maybe the buyer will be interested in paying instead of the seller, but then he will be able to recoup from the seller if he finds him in Hawaii. Some conclusions to draft from this is that the conclusion that can be drafted from the presentation is that condominiums have been very popular in Spain since 1960. This is in part thanks to the very well-balanced legislation that has allowed the widespread of home ownership among households and many other uses. However, delinquency within condominiums remains as a matter of concern. While numbers show that circa 40% of Spanish condominiums have delinquent co-owners, continuous reforms of the law try to improve the remedies that condos may use against them. And these remedies of condominiums can be organized in three groups. First, they tend to limit political powers of defaulters, no voting rights, cannot challenge illegal decisions of the assembly. These remedies also limit the delinquent owners' rights of use, for example, barred from using certain common elements. Or third, these remedies try to reinforce the strength of the credit of the loan of the condominium, giving it a privileged position ranking before other credits, increased interest rates, a fast judicial process, and this guarantee in case of sale of the unit. So thank you very much for your attention. If there is any question, I am ready for help. Thank you.
Fantastic. Thank you very much, Sergio. I really wanted the audience in Scotland to be able to hear about the law in Spain, because I know that the range of remedies that condo owners have there to try to enforce debts against other owners or for delinquency is quite extensive, and I'm interested to know really how some of those ideas come across in Scotland. So, the idea that you might name and shame, have the list of delinquent owners and for that to be published at the annual meeting. I think that might be quite challenging an idea in Scotland. Or similarly with the idea that condo owners can vote now to exercise particular measures against their neighbours, maybe to even evict them from their flat for a period of time, or so to try and get some of the money back, or to prevent them from using some of the common areas. I think these are ideas that have just never really been kind of even discussed in Scotland, where the focus is still very much more on how do we use the property to extract money from somehow through some kind of charge or mortgage or some sort of remedy like that. So these are measures that probably are much more on the cultural, behavioural kind of side of things rather than on the purely financial side of things, which I think is really interesting. But yeah, be interested to kind of hear how that has come across to some of the attendees on the call. What I'm actually going to do, rather than doing the Q&A now, is just skip right to hearing from Vincent, and then it means that we can have a bit of time for Q&A at the end with all the speakers, hopefully, because you might have seen had some questions in the chat now that maybe everybody might like to sort of pitch in on. So I think what I'll do at the moment is just, Vincent, if you're there, ask you to join us and tell us about the law in Belgium. If you want to make yourself visible to us. Oh, good, you are. I was like, oh, it's going to be awkward if you've nipped off the call for 10 minutes. Yeah, okay, so I think it would be good just to get the final piece in our puzzle, which is the law in Belgium. So Vincent Sager is a professor at KU Leuven, in, again, bad pronunciation, in Belgium, and also the director of the Institute of Property Law there. Vincent, I think, is also in a unique position amongst our speakers in the call in that he has been directly involved in recent reform of apartment law in Belgium. So apartment law in Belgium was amended in 2018 as a result of work carried out by a ministerial working group, which Vincent co-chaired. So he has been very up close and personal with these questions of how you can improve apartment law in general, but also I know as part of that reform there were changes to the debt enforcement rules in Belgium. So hopefully we'll be able to hear about not only the difficulties of that process, but how it's been operating in practice since the law changed. So I'll hand you over to Vincent now, and then we can all come together at the end for some questions.
Thank you very much. I hope that you can hear me.
Yep, yes we can.
Okay, thank you. I try to upload my PowerPoint, if that's working.
Yep, that's come through now. That's great. Thank you, Vincent.
Great. Thank you very much, Frankie. And thank you for organizing this and also involving Belgian law into this webinar. And I'm realizing that as the law speaker, Belgian law is not the most interesting legal system, I think, because it's by far the smallest legal system which you have involved in this webinar. I'm always thinking that listening to Belgian law for a foreigner must be something like listening for me to Luxembourg law or something, which is very often conceived as a small legal system and so less important legal system. But we have gone through some reforms in Belgian law quite lately, not only in the field of apartment law, but we have gone through a reform of Belgian property law in general. We have introduced a new book on property law in our civil code, and that has entered into force on the 1st of September 2021. And as you have said, Frankie, Pascal Lecoq and I, who were in charge of that reform, have parallel to the big reform, also headed a group, a stakeholders group, in order to reform also the rules on apartment law, which have been introduced in that new Belgian property law afterwards. And as in many countries, the Belgian apartment law has been introduced in the aftermath of the First World War. So in 1924, we had our first large or extended rules on apartment law, but the current system of apartment law dates back from 1994 and has been refined in 2010 and has afterwards been drastically refined again in 2018. And I think that there were two main driving forces reforming the apartment law in 2018. On the one hand, we've tried to make apartment law more flexible, because you have to know that in Belgian law, I would say the building park is quite old. More than 2/3 of our apartment buildings are more than 35 years old and need renovation or even need demolition and reconstruction. And so we have tried to make our quite rigorous rules on apartment law a bit more flexible. That was one main driving force. On the other hand, we have tried to make the system more efficient in order to safeguard the financial streams and in order to make the recovery of debts more efficient. We have not been as efficient as in Spain, well, efficient according to some and harsh, I suppose, according to others, but we have to introduce some measures which could help in that regard. Very briefly, with regard to the general framework, we have in Belgium a dual list system on apartment law, meaning, as in Portuguese law, if I'm remembering it well, Sandra, that an owner has an exclusive, a full ownership on his private unit and has a co-ownership, a share of co-ownership in the common infrastructures together with the other owners of the flats. The share in the common areas is determined in function of the value of the apartment, and it should be determined in an objective manner. So there are several criteria, several standards which have been taken into account in order to determine the value of the apartments, and that determines in turn the share you have in the common areas. And the share must always be connected to the exclusive property right you have on your own flat. The share in the common areas is not always identical to the proportion you have in the charges. Because the proportion you have to bear in the financial charges of the common areas is determined in function of the value of the apartment. That's the same standard as for the shares, and or in function of the use of a common area for that apartment. For instance, a very common example, the owner of an apartment on the ground floor will very often in the bylaws be exempted from paying or contributing to the charges in the elevator. So you can combine both, but it's not so that the shares in the common areas are always identical to the shares in the financial charges for the maintenance and the reparation. The rules on apartment law are mandatory, and this is an exception to the general property law, in which the rules are, since the 1st of September 2021, suppletive and can be contractually derogated. The central vehicle is an association of co-owners, which in Belgium has legal personality, but it can only be used for the administration of the common areas, administration meaning maintenance, repair, etc. And there are several organs within that association of co-owners. The building manager is the executive organ, there is the General Assembly of co-owners, and there is the financial commissioner. The General Assembly of Co-owners votes with regard to all the different aspects once a year, or there can be a specific or special meeting of the co-owners. And normally each owner has voting rights in function of the share he has in the common area. So the weight of the vote is determined in function of the share you have in the common areas. And the fact that the Association of Co-owners has legal personality means that it has an own estate, and the estate of the Association of Co-owners is determined or is composed of the contributions which are paid by the co-owners as determined by the General Assembly. Now, jumping immediately into the financial dimension of the Association of Co-owners, I have asked several questions in the presentation. First question, how does Belgian law incentivize long-term financial sanity of Association of Co-owners? Until now, we don't have a lot of association of co-owners which have solvency issues, contrary, for instance, to French law, where you have that problem in a very manifest manner. But we have tried to take some measures which should avoid insolvency proceedings against association of co-owners. An association of co-owners, as I said, has a proper estate, but the estate is divided into two components. On the one hand, you have the operational fund or the working fund, which has to pay the operational operational expenses of the common areas, maintenance, the litter bins, etc., the management costs, and the expenses of the building administration. But on the other hand, you also have the reserve fund, which has to pay, or from which you have to pay the exceptional expenses, such as the reparation of the roof or of the elevator, or where there have to be exceptional renovation works in the building. And in 2018, for the first time, the legislator has obliged Association of Co-owners to create a reserve fund. Before, it was just done on a voluntary basis, but since 2018, it's compulsory in that sense that 5% of the contributions of the apartment owners to the Association of Co-owners must be transferred to that account, to that reserve fund. And the idea is that these exceptional expenses should be gradually built up during the years, during the decades, instead of being confronted suddenly with an unexpected expense. And at that moment, all the owners try to sell their apartment, but nobody succeeds to do so because everybody sees what's at stake. So we try to gradually construct, and I know that 5% is by far too little, but it was very difficult to increase that amount, for instance, to 10%, as we heard elsewhere. But politics were very reluctant to increase the expenses of the co-owners within an apartment. This was in a period just ahead of elections, and they wanted to avoid any political risk. In two cases, there is no obligation to have reserve fund. First of all, during the first 5 years of the existence of the building, we assume that during those 5 first years, there are no large expenses which have to be made on the one hand, and on the other hand, well, after having bought an apartment, this is a financial precarious situation for a lot of owners. So we have tried to exempt these owners during the 5 first years. Secondly, if 80% of the votes brought on the General Assembly decides not to reserve money for unexpected expenses, then you don't have to do those 5%. But only if 80% of the people agree not to look to the day after tomorrow, they will be exempted. Of course, you can reserve more than 5% on the basis of just an absolute majority for that reserve fund. Second measure for the long-term perspective is that the building manager should also bring that long-term financial perspective on the agenda of the General Assembly each year. As I have said, the Association of Co-owners has legal personality that can create some problems for creditors of the Association of Co-owners, for instance, for contractors which have repaired the elevator, which have repaired the roof, etc. Normally, they should execute their claim. They should realize their claim on the estate of the Association of Co-owners and not on the personal estate of the owners. However, there is a subsidiary, I would call it, liability of the individual owners, because the enforcement of the decisions in which the Association of Co-owners is condemned before court may also be done on the assets of the individual estate of the co-owners, but they are not liable on an indivisible level. No, they are only liable in proportion to their share for the voting in the General Assembly. You must also know that in this regard, we have introduced in 2018 the rule that only those owners who financially feel the impact of a decision can take part in the decision making. That's the rule the payers decide. For instance, if the owner of an apartment on the ground floor must not pay for the elevator or for the maintenance or the reparation of the elevator because the bylaws exonerate him from paying in that elevator, then he will not be able to take part in the decision making on that elevator. So only those owners who feel the financial consequences of a decision can take part in the process of making that decision. We have considered introducing the rule, as in Spain, that if you didn't pay because you were in default, then you may not take part in the decision making. Finally, we did not introduce that rule because we feared that it would come across constitutional principles of protection of property rights, and I must say there have been some constitutional challenges against the new act, but so far we didn't have any drastical annulments of our new reformed act. There is one final ultimum remedium, I would say, which can be taken if there is a serious affectation of the financial situation of the association of co-owners. If the financial equilibrium of the co-ownership association is seriously affected, then the court can appoint a provisional administrator, and the provisional administrator can take whatever measure he thinks is useful. He can do it at the expense of the association of co-owners, and he can do that even by substituting himself to the General Assembly. Not only by substituting himself to the building administrator, but also by substituting himself to the General Assembly, which he can avoid and which he should not consult. Final question, important question. How does Belgian law make the recovery of amount due by the owners more efficient? As I told you, the association of co-owners has a proper estate, and the estate is constituted, is composed by the contributions, by the charges which are being paid by the individual owners in function of the proportions determined in the bylaws. Well, how can the association of co-owners act if it is confronted with an individual owner which does not pay its portion in the charges? We have taken some measures to make that more efficient in 2018. First measure is that the building manager, the building administrator, so that executive organ of the association of co-owners, can take all judicial and extrajudicial measures for the recovery of the contributions without prior approval of the General Assembly. So the building manager has de jure the right to initiate judicial proceedings to sue individual owners if they are in default of paying their contributions. They can do so, they can initiate those judicial proceedings at the court, the judge of peace, as Sandra told it also, I think, in Portugal, which is the lowest tribunal, which also has a large perspective on mediation. It always tries to get into an agreement between parties before imposing measures. There is an explicit rule in our act, in our civil code, that bylaws of apartment buildings cannot have any arbitration clause. So arbitration clauses in the bylaws of an apartment are void. The reason being that the legislator had the fear that the building companies would monopolize judicial proceedings, because arbitrators very frequently are quite expensive, and homeowners cannot always afford an arbitrator, while a building company can afford an arbitrator. And that's the reason why they have the legislator has excluded arbitration clauses in the bylaws. Secondly, and I heard that measure also by Sergio in Spain, he called it a tacit charge, but we mean the same, I think. I call it a statutory right of priority in favor of the association of co-owners. So the association of co-owners has a statutory right of priority on the private unit of the defaulting owners. We have introduced that in the 2018 amendment, both at the request of the stakeholder groups of owners and at the request of the representatives of the building administrators. I was a co-president of that commission, and I was very unhappy with that. But if the two conflicting stakeholder groups ask the same thing, then you should not oppose too much. Why did they ask that? Well, because they, on the one hand, the building administrators, of course, are the victim if they have a gap in the budget, because they must make sure that they can pay the accounts and the debts of the association of co-owners on the basis of the available budget composed by the contributions. On the other hand, if there is a gap in the budget, at the end of the story, who will be the final victim? Well, it will be the other owners who will have to fill in that gap by increasing their contribution to the association of co-owners. So both stakeholders group agreed on that point. Finally, the tacit privilege is quite limited in scope, because it only guarantees, the security claim is only the charges of the current year and the charges of the last year, of the preceding year. The object is the private unit of the defaulting owner, and in case of seizure and foreclosure, the sales proceedings of the private unit. It is a very strange animal, that statutory right of priority, because it's a tacit privilege on an immovable. Normally, if you have a statutory priority on an immovable, then you should register it in the land register, but here it's not the case. So no publicity at all. It's a concealed, it's a silent priority right. And I should not tell you that the banks, the financial institutions, were not happy with it, because it gains priority over the conventional mortgage, the conventional hypothec of a bank. So they were not happy with it, and that's one of the reasons why the scope on the level of the guaranteed claim is quite limited, in order not to burden the mortgage credit, in order to avoid that it has some legal economic effects on the cost of the credit. We also have some measures, and quite similar to what I heard from Sergio in Spain, some measure of clearing payment arrears in case of transfer of an apartment. So the legislator was afraid that if the owner of an apartment sells his apartment at the moment that he is in default, that he would disappear, that he would disappear in the bush, they would never retrieve him, and that the arrears would not be complied with afterwards. We have been thinking in 2010 about a kind of a right to follow. So the possibility that the new owner, the buyer, would be liable for the historical arrears built up during the period that his predecessor was owner. Finally, we didn't do that because it would go against some principles of contract law, privity of contract, etc., etc. But we did something else. We introduced another system, and the other system is that at the moment of the sale of the apartment, the public notary should consult the building administrator and should ask him whether there are any open debts on behalf of the seller. And he will get informed on that. He will, the public notary will mention that also in the notarial deed. The public notary in Belgium always makes sure that the sales price is transferred through his trust account. Yeah, the buyer pays the sales price on the trust account of the public notary, and after passing of the deed, the sales price will be transferred to the seller. Well, in this case, in the case of the sale of an apartment, the public notary will keep the money, and he will distribute first the money among the known creditors, being the mortgage creditors, the other preferred creditors which have registered a seizure or a right of preference into the land register, and including also the homeowners association, the association of co-owners, because it has since 2018 a statutory right of priority, statutory preference. So there will be what we call a mini distribution of the sales price among some of the specially protected creditors in Belgium, and the remainder of the price will be transferred to the seller himself. But that moment, the moment of the sale of a unit, is an important one, because we try to avoid that the sale of a unit is a way of escaping the debts which one has incurred over the years. Finally, final measure. In Belgium law, very often a private unit is burned with usufruct, and very often it was very difficult for the association of owners to know whether they have to direct to the usufructuary or to the bare owner. Well, we have solved the problem by stating that there is an indivisible liability between both. Coming to my conclusion, the law will not solve all problems. I always say it's already very difficult to live together with a person of your choice. So it's even more difficult to live together with persons you didn't choose. And that's the reality of apartment law, that you live together with people you didn't choose. But we have tried to make Belgian law a bit harsher than it was and a bit more efficient than it was before. Sorry, Frankie, to have exceeded my time, and thanks for your attention.
Not at all, and thank you. That's another excellent presentation. I really enjoyed that. I think one of the things that's interesting that comes out of the Belgian law is that, and that we're going to have to wrestle with here, is you can put some sort of priority charge, whether you call it a charge, a security, a mortgage. You can give some sort of priority to the debt that is owed to the owners association over a debt that is owed by the individual delinquent owner to their bank. So, you know, you prioritise the owners association over the lending bank. But the question is, to what extent will the banks in this country kind of go along with that idea, you know, buy into that idea? Is the reality of us introducing that sort of measure that banks will then be less willing to lend money to people to buy tenement flats? You know, there are these kind of systematic knock-on effects that we need to think about when we're trying to figure out what the best balance is in the legislation here. So the changes that were made there in Belgium seem to me to be very measured, which I assume was partly with that, some of those kind of concerns in mind. So but I think those kind of financial remedies are probably more what we're looking at in Scotland, maybe less so than some of the more behavioural type remedies that they have in Spain, although the audience may disagree. Okay, so let's do some Q&A. I'm going to go through some of the questions that are in the chat and maybe just put them to the speakers generally. So the question that Susie Robertson had been trying to ask before she lost connection before was about the shares. So she says that in Scotland, commercial units historically have higher shares, so are responsible for more of the costs within a condominium block than residential owners. So I don't know how common this is in other countries, but in Scotland it's quite common that you might have a building that maybe has some shops or commercial units on the ground floor, and then up above that are residential units. So quite often the commercial units will be responsible for more of the costs, a bigger percentage of the costs. And Susie's saying that in her experience, that can often stop repairs going ahead, because if the commercial unit just says no, and they are potentially least affected in the sense that they're not living in the building, because they've got the majority of shares, it can be a block. So does that situation arise in other places, or, you know, we got a fairer system than that, is what Susie's asking.
Yeah. In our country, if I may, is very common. We have the flats and then the shops, and then under Catalan law, precisely, it is specifically regulated that the assembly can introduce in the bylaws or simply take the decision to increase the contribution of these commercial places up to the double of the ideal share that they should have. Let us say that they represent only 10%, let us say, of the condominium. They should be obliged to pay up to 20%. But then you have to justify that. It's not so easy. When I was a judge, I saw two cases. One was about a kindergarten, and the other was about kindergarten. It's understood also in English. Kindergarten, and the other one was a language academy. The difference between both was that the kindergarten was in the ground floor, so they didn't use any kind of common element. They had their own entrance outside the building and so on. So this was dismissed, saying no, you cannot increase because it's not justified that this type of commerce will use common areas more often than the other ones. But the language school was in the third floor, so this was granted. Yes, okay. Because you see 20 children coming up and down every half an hour. So okay.
Okay. Yeah, in Poland, if I may, the situation is that the share is calculated in exactly the same manner for all the units in the building, and the measure that is used 99.9% of the time is the usable area of the flat. There is another possibility, but it's an exception. It basically isn't used, so I'm not going to talk about it. So what you do is you calculate the share by dividing the usable area, or it's a fraction of the usable area that you have, by the usable area of all the units in the building, and that is always the same. So as far as voting goes, that stays. But for non-residential flats, there can be a resolution that is taken by the community to increase not the share and not the way it's calculated, but just increase the payments that are made towards contributing to the cost of maintenance, but only if it is justified by the manner that unit is used. So what Sergio has said, if you have a unit which is used for commercial purposes and it really does result in more wear and tear of the common parts, then you can increase it. But if it doesn't, then it just won't be justified. But it's a question of separating the contributions from the share, because the share is still the same and the voting is still the same.
Okay, I mean, that is interesting to think about that, because I think in Scotland we tend to think, you know, you're sort of one person or one flat, one vote, one equivalent contribution, everything's all kind of together like that. But, you know, of course, it doesn't have to be that way. And that idea of separating out what your voting rights are from what your financial contribution is might be another way of finding some kind of balance between different owners within the building.
I mean, that's in Poland, that's allowed only for non-residential units. So you can only separate that for non-residential units, and only if you can justify that the manner of using them necessitates this different approach to whatever payments they are making. And in a very rare situation, when you have, for example, 3 co-owners, let's say heirs, like Sergio said, who want to establish ownership of units, and instead of calculating the floor area, if they do it all simultaneously, so it's like one act in law by which all the units are isolated, the act gives them the possibility to say, okay, let's just say 1/3 shares all of us. We're not going to do the calculations of the floor areas because it's more or less the same. We'll do it that way. But in practice, that happens very, very rarely.
Okay, right. Thanks. That's really interesting. I'm going to just skip on to another question. So sorry if I'm cutting off Sandra or Vincent, who were going to come in on that. I'm just conscious of time. So one of the other questions that we were asked in the chat there by Jackie Riley was about reserve funds. So I think this is an interesting question generally, is how is it decided what contribution, the level of contribution that people need to make? You know, who decides, or how is it decided how much money needs to be paid in? And if that's a question of maybe a vote amongst the owners, then is that also a kind of a source of conflict? So I put that out to any or all of the speakers really. How do you decide how much people have to pay? Vincent, did you put your... Sorry, Sandra, you go.
Okay, sorry. So in Portugal, we have a very strict regulation. So the amount is 10%. So co-owners can decide a bigger amount of money, but not a smaller. So 10%, and the fund is only for repair works. So it cannot be used for any other purpose.
I think the question, but 10%, you know, like 10% of kind of, like how do you decide, you know, 10% of what?
Of the financial, of the monthly contribution.
And how do you know what that monthly contribution is? Is that
it's decided in the general meeting?
Okay, so the owners decide.
Yes. And of course, it depends if it's a bigger building, you'll have more co-owners and you have more substantial reserve funds. If it's a small building, you don't. But it's strict like that.
Okay, all right, thank you. Did any of the other speakers want to come in there on that question? Vincent?
Yeah.
Yes, in Poland, oh, sorry.
Oh, go ahead, Magda.
So in Poland, you have to approve a budget for the community, and in that budget you simply make a list of all of the expenses, and some of them you know what are going to be, because you know how much cleaning or taking the trash out and all of that is going to cost, or insurance is going to cost. So and then you allocate on the basis of shares, but then in the budget you can also make plans for some repairs and for some extraordinary circumstances. So you have to make that budget, approve the budget, agree on, you know, the positions that are future costs that may or may not come, and then on that basis you would calculate what the contributions on a monthly basis would be.
Okay, all right.
But we have no reserve fund. All
right. Vincent, you had your hand up there.
In Belgium, the General Assembly decides on the reserve fund, but the statutory minimum is 5%. If you want even go below the 5% or not to install a reserve fund, then you need 80% of the votes of the owners not to create a reserve fund. But normally it's 10% of the total amount of the normally it's 5% of the vote of the total contributions, which has to be transferred to the reserve fund. Sandra, I was confused by yours.
I think that this is, you know, in Scotland at the moment, we don't have anything like this. There is no kind of reserve fund. Nobody pays any money anywhere. So to me, the question is kind of, if people can just vote, don't the owners just vote to pay nothing? You know, if there's no, the idea here is that it's going to be imposed on legislation. Legislation will assess how much money based on the property values and things that you're supposed to pay in on a month-to-month basis. Because if we just left it up to owners to decide, mightn't they not just decide to never contribute anything?
Reserve fund, our system is similar to the Portuguese one, but I may say it's an essential element for making a condominium working, because then you have always money, little money, or the professional administrator or the president of the condominium, whoever has money instantly to make little reparations, little things that are urgent, like, I don't know, roof leakings, or new paintings, or repairing the elevator, or buying some bulbs to repair the lights. You know, this is absolutely essential for also the cohabitation, the proper cohabitation of people. Yes, saying, oh, the elevator doesn't work, there is no light in my corridor, why I have to pay for this? You know, this kind of thing. So you have always to, but there is one thing, there is a tricky thing. If you sell the apartment, you cannot recover the amount you have paid for the reserve fund for a number of years. I mean, you have been living there for 20 years, let us say, and paying for the reserve fund every year. You can recover a coin, which means that, yeah, it's a bit weird, yeah, but yeah.
Okay, well, I mean, I think that, again, there's maybe like a behavioural question there where I think, you know, in a country where you're just used to the fact that you have to pay in, it wouldn't really occur to people to not, you know, they wouldn't find it strange to be asked to pay in or to consider that as sort of an expectation. I mean, they might not do it or they might not have the money, but, you know, there's an expectation there, which I think just doesn't exist in Scotland at the moment.
Can I just quickly say the provision that we have is that owners are obliged to pay a contribution on a monthly basis towards the cost of maintenance. All right.
Okay.
So it is said now, it doesn't say how you calculate the cost of maintenance, and that will be done when you work on the budget. And you can work on the budget and say, okay, we are just going to calculate whatever costs we have, and we will have a really small margin for any extraordinary repairs. And in new buildings, that's what usually happens because you don't expect many things to go bad. If it's older buildings, then owners will agree on a larger margin because there will be more unexpected circumstances that arise. But the lawmaker requires them to pay on a monthly basis a contribution towards the cost of upkeep.
This is fascinating stuff. Now, I'm very conscious of the fact it's 11:30, which is when this webinar is supposed to end. If anybody needs to dash off, you know, please just go. But I am just going to ask it to go through these 2 more additional questions if people don't mind hanging on. So we had one more question in the chat that I wanted to ask from Joan Beattie, and then we do have another person with their hand up for a question. So I'll go through these 2. So Joan's question was Joan Beattie's question was a sort of a practical question about if you're in a situation where you've got delinquent owners, but work still needs to be carried out. Okay, so you've got enforcement processes, but in the meantime, how can the works go ahead? So one of the ways that we deal with that in Scotland, within Edinburgh, the council have this missing shares, what they call a missing shares scheme, where say you've got one person that hasn't paid in their money for work to be carried out. The council will pay in the money, you know, to cover the gap, like to cover the missing contribution. And then in the end, the council will try to get that money back. You know, the state will try to get that money back from the delinquent owner. And it means that the work can go ahead, but eventually the delinquent owner should be forced to pay. I just wondered if that is a problem. You know, does that also come up in some other jurisdictions, and is there a mechanism for dealing with that? I mean, I guess if you already have the reserve fund, then maybe it's not such a problem, you know, in that kind of project to project sort of way. Ansel?
Yeah, we solve that through that subsidiary liability of the owners themselves. So we don't have a state which is as friendly as in Scotland, apparently, Frankie. So if the homeowners association really is in default because of a gap created by one of them, then the other owners will suffer from that.
Okay, so suffer in the sense of the work will not be able to be done, or suffer in the sense of they will be expected to cover the gap?
Second.
Okay, all right. So it's just left to the other owners to deal with. Is that the same elsewhere?
Well, in Poland, I mean, the bottom line is if there is not enough money in the pot and the default ones are not willing to cough up the money, then the work will not go ahead and you will have to wait for the effect of the court proceedings, or maybe there will be some, indirect motivation of the other owners that will try to convince that person to pay. Yeah. Yeah.
Okay. All right. Yeah, that's really helpful. This is sort of coming back to the point that Annie was making in the chat there about access to efficient judicial resolution mechanisms and the extent to which that may or may not be possible in Scotland too. So that's interesting. Okay, let me just go for this one final question. I've completely lost the... Jackie Riley, you had your hand up there. Do you want to make yourself visible and ask your question?
It was just in relation to the reserve fund, but I was going to ask the same question as you had asked, Frankie. It was just about, you had asked where does the contribution come from? So that you had asked that question as I put my hand up.
Okay.
What I did want to know was 10% of what? 5% of what, but obviously the assembly decides it in some places and the owners decide it in others. So yeah, that was why I'd put my hand up, but you then asked that question that I was going to ask anyway. So
okay,
yeah,
good. So long as the question,
thanks, that's interesting. Thanks.
So long as the question's been dealt with, then that's great. I'm just going to ask one more question of Sandra in particular, which is the justice or the judge of the peace system that you have in Portugal, which can resolve maybe more efficiently disputes. Do people have to pay? Like, is there a charge for having your case heard or dealt with by that tribunal?
Yes, 40 euros.
Okay, it's just that flat fee, 40
Yes.
euros, and that's okay. All right. Because I think that question of what dispute resolution mechanisms you have access to is obviously pretty critical in this area. And I think one of the difficulties in Scotland at the moment is, I mean, you can go to court at the moment, but it's a very, you know, can it be quite a long and involved procedure, even on the sort of simplified end of things. So it's something that we need to look at here too. Okay, that has been a really fascinating session, and as always, I was like 2.5 hours is quite a long time, but as always, it seems like maybe we could use another half an hour just to keep having the chat, because it's so incredible to have such expertise on the call and to be able to learn so much about what's going on elsewhere. But probably better finish things off, so all that remains is for me to say thank you so much to all of you for giving up the time, not just to make your presentation, but also to stay with us and continue the discussion for the rest of the webinar, because personally I've found it all fascinating, and I'm sure that's been the same for the others on the call. Hopefully, once assuming our recording or technology has all worked out okay this time, this recording should be available on YouTube over the next week or so, so people that can't maybe make it along during working hours or whatever can catch up on this afterwards. And just, yeah, thanks again, and have a lovely Friday.
Thank you very much, Frankie. Thank you for organizing this.
Thank you very much. Bye bye, everybody.
Thank you to all the speakers.
It was
Thank
really
you.
nice to meet you again.